So you use the word, the constitution doesn't use the word reasonable restriction.
To ensure the formation of linguistic states was a leap of faith.
I don't think they were necessary.
Elon Musk or Mark Zuckerberg can't be the only arbiters of what is allowed and what is not allowed.
We were not a theocratic state. We were definitely not a theocratic.
Then you go down the Afghanistan way or any other way where people are publicly shot. That's not who we are as a people.
On this 75th Republic Day, we celebrate the cornerstone of our democracy, the Indian Constitution. Enacted on January 26, 1950, it stands as a testament to the vision of justice, equality, liberty, and fraternity. Framed by visionary leaders, it remains the guiding light of our nation's governance, embodying the aspirations of a diverse and a united India. Let us honor its principles and reaffirm our commitment to upholding its values. Drafting such a complex document for the betterment of more than 1 billion people was never an easy job. The needs of the people keep changing, and so does the Constitution. Today, we reflect on the resilience of the Indian Constitution, strengthened through thoughtful amendments. The First Amendment, enacted in 1951, marked the pivotal moment, addressing the freedom of speech, land reforms, and social justice. It introduced reasonable restrictions on free speech, empowering the state to curb misuse while safeguarding public order. But what does the word reasonably actually mean?
It's quite ironical, first of all, when you look at it, the US First Amendment gave them freedom of speech. It's the Bill of Rights. Basically, the First Amendment of the US is the Bill of Rights. Freedom of religion, freedom of speech, etc., etc. And our First Amendment curtailed the freedom of speech. The reasons were twofold. One was a magazine called Crossroads, run by Mr. Ramesh Thapar. And another was the organizer, the mouthpiece of the RSS. So one was a left-leaning magazine, one was totally right. And both were hurt by the orders. You know, when you look at only those two cases, people discuss these two cases, it does look like this, as if this amendment was too harsh. But people forget that there was another case. Justice Sarju Prasad of the Patna High Court, he held that even if you incite somebody to murder, it's freedom of speech. You can't catch hold of them. So things are going a bit too far. So you use the word, the Constitution doesn't use the word reasonable restriction. The Constitution restrictions of this nature. So they are meant to protect the public. But unfortunately, they've been used to muzzle the press rather than protect the public. Nobody defines. And it's best that left undefined, I think, because you can never have a very, very precise definition of reasonable. I can't enter somebody's bedroom and say, no, it's my right, freedom of speech, to see what is there and broadcast to the world what is happening. So there's a right, there's always that conflict between the right of privacy and the freedom of speech.
The Seventh Amendment, enacted in 1956, was a landmark in reorganizing India's states and territories based on linguistic and administrative considerations. It streamlined governance, abolished Part A, B, C, and D states, and introduced a unified structure of states and union territories. But how important was this division when it comes to the Indian subcontinent?
When the Seventh Amendment came through, it was after Potti Sri Ramalu's fast, and he fasted for an Andhra linguistic state. At that point of time, there were many of these provinces which were linguistically diverse. You had the Bombay province, you had the Madras province, and people spoke all languages in that province. There was always the fear in the early stages that having linguistic states would lead to subnationalism and would possibly lead to a break of the country. You must remember that there was a very strong sense of the South Indian languages, especially Tamil, asserting that it would not be spoken to in Hindi. So at that stage, to bring in this constitutional amendment and to ensure the formation of linguistic states was a leap of faith. But if you look at it, you have to see across the border to see how religiously a homogeneous country yet got divided by language. So Pakistan was built on Islam, but then it split into West Pakistan, which became Pakistan, and then you had East Pakistan becoming Bangladesh. We've had a sense of balancing and compromising where necessary.
The 42nd Amendment, enacted in 1976, is often called the mini constitution due to its sweeping changes. It added the words socialist, secular, and integrity to the preamble, reinforcing India's foundational values. It also expanded the scope of fundamental duties and strengthened the directive principles of state policy. While controversial, this amendment highlighted the Constitution's ability to adapt to changing times, reaffirming its role as a living document. What do experts say about it?
I don't think they were necessary. I think this was when they wanted to bring the 42nd Amendment, and the main purpose was to say that Mrs. Gandhi stays in power, that the powers of the executive get widened, the powers of the judiciary gets truncated. So they had to do some, varnishing and whitewashing. So like they brought in some they brought in certain things like legal aid, etc. So they also said secular socialist. Socialist, one can have a little bit of a discussion whether this is part of the original. As far as secular is concerned, if you go through the Constituent Assembly debates, though the word secular may not have been used anywhere, if we read the preamble, you see, we promise to ourselves justice, equality, and most of all, which people forget, is and fraternity. See, fraternity is so important. Fraternity assuring the dignity of the citizen. How can there be fraternity if you don't respect each other, if you don't respect each other's cultures? Then from Article 25 to 30, you have religious freedoms. So it was never, we were not a theocratic state. We were definitely not a theocratic state. And therefore, we were a secular, whether the word secular is written in the preamble or not, for me, the Constitution speaks of secularism even without the word secular. As far as socialist is concerned, there are two concepts. We may not be socialist in the sense of a communist. When our founding fathers made the Constitution, they may not have thought of a socialist as in the Union of the Soviet Socialist Republic. A socialist is also a very communist term. We may not have that. You see, that time Mrs. Gandhi was being aided by a lot of the, like Kumaramangalam and all, who were very leftist in their approach when these amendments were brought about. But we were definitely a welfare state. When we talk of equality, economic equality, justice, in the preamble, what are these promises? These are nothing else but economic justice. How do you have economic justice if 70% of the wealth is held by 1% of the population? I mean, generation of wealth is very welcome, but the distribution of wealth is also very important.
Our Constitution is a flexible and people-friendly document. Fundamental rights, particularly Article 19 and 21, now encompass digital freedoms, including the right to free speech, privacy, and access to the internet. Landmark judgments like Puttaswamy versus Union of India have affirmed the right to privacy as intrinsic to Article 21, ensuring protection in the digital realm. These advancements reflect the Constitution's ability to safeguard individual rights while embracing technological progress, fostering a more inclusive and connected India. Let's see how these rights work in today's political climate.
See, this is a evolving subject, and social media companies which are owned by big business have long relied on self censorship and moderation to justify the vast power of reach that they have. But that is changing. It's changing abroad, and moderation no longer works. And even moderators have often been discreetly told by people to shut down certain accounts or to limit their reach. We do need a legal framework as to what can be done and what can't be done, and that is a matter possibly for Parliament to review, and there should be a legislation. It is unsafe to leave it to the discretion of a few media moguls. Elon Musk or Mark Zuckerberg can't be the only arbiters of what is allowed and what is not allowed. Not all speech is criminal just because somebody thinks it is. And that you have to speak in order to think. And a thinking citizen is the basis of our republic.
Reservation has always been the epicenter of public debate. The 93rd Amendment, enacted in 2005, added Article 15, Para 5, enabling the state to make special provisions for the advancement of socially and educationally backward classes, scheduled castes, and scheduled tribes in educational institutions, including private but not minority institutions. How has this policy worked for the Indian people in recent times?
See, there has to be a balance between the two. When we talk of equality, see, our constitution talks of equality. The preamble talks of equality. Article 14 talks of equality. 16, 15, 16 are all manifestations of equality. But when you talk of equality, you can't equate oranges and apples. If somebody has been deprived, there are some sections of society which have always been deprived. You will have to give affirmative action. And affirmative action must be balanced at the same time with seeing what is the results. Unfortunately, we are only now, what is the affirmative action has become only a vote bank politics. Now we have castes which are dominant in the political field, castes which are very powerful, saying that we want both in Rajasthan, Haryana, you have it in Maharashtra, castes saying that we should be declared backward classes. Now, when that happens, then there is a problem. If it is only meant for those who are actually genuinely deprived, and I think that also, I don't know, the Supreme Court has not said this, but I am still of the view that I'm not saying limited to 10 years or 20 or 50 years, but limited to once a family has it for one generation or two generations or something, the benefit of that, then you should end it to that family at least, if not to that caste. Somewhere it has to come to an end. Now, people can't reap the benefits of that for 10 generations.
Every country has crimes which forever change the people. The 2012 Nirbhaya case was one of them. How did our legal system navigate through this unfortunate and complex case? Were there things we missed, or was justice served?
No, crimes against women are many, and Nirbhaya was a very violent crime against women. It was an extreme case. So crimes against women is a whole different subject altogether, and it requires much more of discussion. But as far as the Nirbhaya case was concerned, it actually happened because of constant media attention. And there are many other cases which are far worse, but they don't capture the public's imagination. I was told by journalists that this was just an ordinary case which one reporter happened to be there and sent a report back to his desk on a day when it was winter, depths of winter, and there was nothing much happening. It was a slow news day, as the saying goes. And then once there was public traction and interaction, which then also fed in to certain political plans, because then the then Delhi government was put in the dock. It really blew up on a nationwide scale. That's as far as the justice for Nirbhaya movement was concerned. As far as the case itself was concerned, I simply think that it became a case of Nirbhaya, whereas it also ought to have been a case of Mukesh versus Union of India, Akshay versus Union of India, and the four accused. I think one was Vijay, if I'm not mistaken, and Pawan. These were the four people who were hung. Their stories.
One juvenile.
Yeah, there were two people who were beyond the law, because one was a juvenile, and the leader, the gang leader, Ram Singh, was murdered in jail. So he never faced trial. So you see, the Nirbhaya case also suffered from a lack of representation for the accused at the trial stage and at the High Court stage. It was only at the Supreme Court stage that Mr. Ramachandran and I were appointed as amicus curiae. We did argue to the best of our ability, and I did not think that it was a case where all four deserved the death penalty, because primarily the lady died because of the insertion of an iron rod, and the evidence was unclear as to who did that. And I don't think that the rest of the people on the bus actually intended it. You were not, with two people being beyond the realm of the trial and the subsequent sentence. You couldn't have been sure whether it was the juvenile or whether it was Ram Singh who had done that act. But hanging all four, I think there was a great amount of public anger, and the case was always about Nirbhaya, and it was never about Pawan or Vijay or anyone else. So to that extent, I keep wondering whether I could have done a better job. I think that the individualization of each of the accused never happened. They were seen as one amorphous mob, and they were sentenced as an amorphous mob. But if individualization happened, then maybe the court could have punished only the full those who participated in everything. Because quite frankly, the entire Nirbhaya incident, from the time that she stepped on the bus to the time that she was thrown off the bus, was about 26 minutes. And there were 6 people on that bus. To say that everybody participated in the rape, I don't think is possible chronologically, if nothing else. So, hanging everybody for rape and murder may not necessarily have been the correct thing. I do believe that a few people could have been saved, but individualizing them was not my role as amicus. They had their lawyers, and their lawyers possibly because they were the only ones that took up the case, may not have been able to do that job. I mean, if you think that the death penalty is a deterrent, I don't think so. It doesn't work, because the criminal in the heat of the crime doesn't expect to get caught. And just because there is a possibility of a death sentence doesn't keep the criminal from going down the criminal path in the first instance. So the deterrent value is limited. Retribution or the sense of collective catharsis, what is that worth? If you want collective catharsis, then you go down the Afghanistan way, or any other way where people are publicly shot. That's not who we are as a people. I think the death penalty should remain on the books, and rarest of rare, in my view, is only an occasional kasab who it is too dangerous to leave alive, because for fear that there can be further hostage situations to try and free him and things like that. But other than that, you now have an option of keeping people in jail for the rest of their lives, ensuring that they never come out. I think that's a better option.
Envisioned as the guardian of justice, equality, and fundamental rights, the judiciary operates independently of the executive and legislature, as ensured by Articles 50, 124, and 211. This separation of powers safeguards the democracy and upholds the rule of law. The Constitution empowers the judiciary to act as the sentinel of the Constitution, ensuring accountability and protecting the rights of every citizen. But as we move forward, how independent has the judiciary actually been? Is independence in the judiciary still alive?
See, I'm a judge. I've been a lawyer. So my thoughts on an amendment will go only to my profession, on what I like. And if I was to dream of an amendment, it would be that High Court judges and Supreme Court judges retire at the same age. Whether it is 65, whether it is 62, whether it is 70. This mad rush to reach the Supreme Court will come to an end. Because once you make the age same, the unholy hold which senior members of the Supreme Court Collegium and all have on the members of the on the Chief Justice and senior judges of the High Court will come to an end, because many of them will not be wanting to come to the Supreme Court if the age is the same. So this will take care of a lot of problems. And the other amendment, same, would be that there should be no post-retirement jobs for High Court or Supreme Court judges. But why? Again, so that people have full faith in the judges. Not that they feel. I'm not saying there are judges who've done extremely good work after retirement where they've been lauded by the government. But people feel the government is one of the biggest litigants in our country. So especially when near retirement, some judgments are passed favoring the government, and few days after retirement, the judge is nominated as A, B, C, then questions will rise. You see, judiciary is independent. There are judges, individual judges, who may not be independent.
But then that's true for every profession.
That's true. So the judiciary is also made up of human beings. It's not cast in gold and comes. It doesn't come. Judges don't come from above. But there's much greater expectation from us. From judges, there's a greater expectation, because that is. I mean, I have never thought that judges are divine. I don't believe that there's any divinity attached to judges. But हम बोलते हैं ना, इंसाफ का मंदिर है. We treat courts and we treat judges as demigods. It's not that every judge has his personal biases, but as long as you remain true to your oath to act without fear or favor, affection or ill will, then nothing can go wrong. But I find, unfortunately, today many judges are influenced by their personal beliefs, their personal predilections, what they personally feel is good for the country. We are not here, judges' duty is not to decide what is good for the country or bad for the country. Judges' duty is just to decide is whether this is legal or illegal, whether this is constitutional or unconstitutional. So if we do that, then there's no problem.
Our journey as a nation stands as a testament to the resilience of democracy, the sanctity of justice, and the undying spirit of our people. The Indian Constitution, our guiding beacon, has evolved alongside our aspirations, ensuring that we remain united in diversity, progressive in thought, and steadfast in our values. From landmarked amendments to pivotal judgments, we have grown together, navigating challenges and embracing opportunities with courage and determination. The stories of sacrifice, perseverance, and vision woven into our constitutional fabric remind us of the shared responsibility to uphold its principles. As citizens, it is our collective duty to ensure that justice remains accessible, rights are protected, and governance is transparent and accountable. Let us reaffirm our commitment to the ideals of liberty, equality, and fraternity, for they are not just words, but promises we must fulfill every day. Together, let's honor the sacrifices of the past, cherish the progress of the present, and work tirelessly for a future where every Indian can dream, thrive, and contribute to the greatness of our beloved motherland. On this Republic Day, let us stand united as custodians of our democracy, guardians of justice, and torchbearers of hope. Jai Hind.